Thank you so much and welcome to Advocate Praise. Thank you so much for joining us and doing this for us today and making the time. Thank you.
All right. Is it okay if I stand this way? All right. Afternoon, colleagues. I am Praise Kambula. Responsible for oversight on the implementation of legislation that deals with the protection of the rights of vulnerable persons. I don't like the use of that term, vulnerable persons. I will tell you later why I'm not happy with it, but anyway, now we have recognized it as one of the pieces of legislation that we have. So I'm responsible then for the monitoring of those pieces of legislation and also then chairing a number of intersectoral committees that are required then to account and implement these pieces of legislation. So today I received the invitation, but I'm not sure whether it got to my office but I just quickly prepared something. All right, hopefully this is what you are expecting to receive, because I was told that it's just going to be about the changes that we have done recently. So that's what I have covered. But mainly, I have covered domestic violence because I think that you are more relevant to domestic violence, to the Domestic Violence Act as amended. Now, how do I move them down? I'm trying to press. Oh, I'm going to do that. Oh. Okay. All right. So I'm going to move from this premise that GBVF, first, in the country, we don't have consensus yet on what we could, what defines gender-based violence and femicide. We don't have that yet. But a decision was made in 2018 that our acronym now must move from GBV to GBVF. That was in that the presidential summit that we had. And the reason is because we want to give recognition to femicide as a pandemic in our country. But currently, we have not yet come up with a country definition on gender-based violence and femicide. What does that mean? And then secondly, we have, of course, come up with a definition, the country definition for femicide, all right? And it was one of the issues that was discussed from the meeting that I came from right now. So, but I don't have it with me right now. I would send it to you. But it is a definition. I think that it is the killing of the female persons without regard to age, sexual orientation, and gender identity. All right, whether perpetrated by a state individually or whether perpetrated directly or indirectly. You see, I got it. I got it. So that definition, then, if you look at it, it is in full compliance with our equality clause that is in Section 9 of the Constitution. Gender parity, sexual orientation, and all that. So it covers, when we say that without regard to any particular gender identity. So we are covering then the gender non-conforming persons, all right? And irrespective of age, because we know that we have experienced a number of killings of children as well, and also sexual orientation as well. So we do have the country definition for femicide, but we don't have one for gender-based violence and femicide. But if you look at this slide, what I'm saying here is that GBVF is rooted in patriarchal social norms, gender inequalities, socio-economic inequalities, family dysfunction, social value, low social value that is attached on women and girls, all right? Because women are killed because you are a woman. They are killed because you don't have enough physical strength, so I can overcome you. It's all those things, all right? The power struggles and so, and also the lack of accountability, all right? And it's just one of the things that I'm saying that are the core drivers for gender-based violence and femicide. But these then, all right, not all of them can be addressed by law. So what it means is that if we change our laws frequently, that could not be the reason for us then for the laws. And we have been heralded by many countries to say that we have put together progressive pieces of legislation and that are globally competitive. So what is the problem? Is the problem because of we have a country that is grounded on patriarchal values and belief systems and so on? Is it because of the economic inequalities and so on? So we need to look at all those things, all right? And you will see that and the main is in the family. Family dysfunctions in the family. If you want to beat gender-based violence and femicide, you have to start at the family, because there is no child who is born a criminal. No, we don't have that. So it's a learned behavior that comes from poor parenting, absent fatherhood and parenting and all right? So those are the factors that actually then build what we call a gender-based violence. And you know that a family, a set of families, they build what we call a community. So there can be no community without families. So if we want to correct the community, we need to start at the family, all right, at the family level. So those are the things that we as parents, we need to take responsibility of if we're serious about getting rid of gender-based violence and femicide. Now, my starting point then is to look at the Presidential Summit Declaration, all right? I asked my office. It's here, all right? It's here, all right? I asked my office to bring it to you, all right? This is got 19 articles, all right? But I have extrapolated these four articles. The first one and the second one, if I can paraphrase them, what they are saying is that every person living in South Africa must take the responsibility to end gender-based violence and femicide. So it's sort of the two are saying to us that you are accountable as an individual. If you are an adult person, whether you are a national or a non-national, by you staying in South Africa, living in South Africa, you have a role to play, all right? That's what they mean. So now, Article 5, which is the one that I'm going to be presenting on, all right? My presentation is inspired by that article, which says that South Africa, all right, just look into the existing laws and see if they are victim-centric, all right? Is the court system victim-centric? Is the criminal justice system victim-centric? What is it that is causing us to have low reporting rate and high attrition in these matters? Why are women dying in abusive relationships and staying in a cycle of violence without reporting? Is it because there's something wrong with your laws are not accommodating the needs and the diversified needs of the victims? All right. So that is what we are looking at. And then Article 9, I put in Article 9, which is relevant to you. All right. It says that now do a comprehensive costing and resourcing, all right, of all these infrastructures that are providing support services to our victims. And shelters expressly stated, all right, that shelters also, there must be that costing and the comprehensive resourcing of these facilities, all right? Because it could be one of the reasons as why women stay in abusive relationships and die. It is because of the fact that these infrastructures either are not poorly resourced, all right, or are providing services that are inappropriate, all right, or not fully responsive to the needs of the victim. So it's either of those, but you are in this document, which is now what I can call like the roadmap for us, South Africa, to implement implement interventions, all right, that will help us to get rid of gender-based violence and femicide. Now, my presentation, as I said, that is going to be centered on these amendments that have been done, all right, but I will mainly focus on the Domestic Violence Act, all right. So as you see there at the bottom, the Domestic Violence Amendment Act of 2021 became effective on the 14th of April, 2023, with the exclusion of one provision, Section 6, capital A, which is about the establishment of integrated repositories and electronic IER, integrated electronic repository for protection orders, all right? So we had to suspend that one because it's a systems development and it has to go into the IJS integrated justice system transversal hub that will require social development to have a system for domestic violence, police to also have a system for domestic violence matters, and sheriffs as well, all right, to have a system. So all these key actors in the implementation of the Domestic Violence Act, particularly in the area of protection orders, they need then to have systems. Those systems then will be integrated in the transversal hub. So thus far, it is the Department of Justice that has a designated system for domestic violence matters, all right? So now, otherwise, the entire act, as you will see it there, I gave it, asked that they bring it to you. So now, we are not calling it that with that citation anymore. As soon as, you know, when you develop a law, it starts with a bill, and then the bill will be passed by Parliament, all right? Going through starting from cabinet and go to the portfolio committee and gets then to National Assembly and the NCOP, then passed. And then after that, then it goes to the president for assent, all right? And signing it into law, moving it now from being called a bill to have an act and also the number, all right? And then after that, then it goes to another process where now, as government together with the civil society organization, are we ready to implement that? So we'll be given an opportunity so that we ready ourselves for the implementation. Then the president, after that, after we have said that, President, we are ready to implement this act, then you will give us the effective date, all right? The date of the commencement of the implementation of this act. As soon as that is done, if it was an amendment bill, then it means that there's a principal act, all right, which is the Domestic Violence Act of 1998. As soon as it gets the date of implementation, then that citation falls away. Now it becomes the Domestic Violence Act number 116 of 1998, as amended. Do you understand? As amended. So that is why you are getting that. That act now incorporates all these changes. All right. It's no longer called, you must don't ever quote Act number 14 of 2021. It was an amendment. It fell off on the 14th of April 2023 and got incorporated in the main act, that is the principal act. All right. Then we have then the second one, the Criminal Law, Sexual Offences and Related Matters Amendment Act. Amendment Act. I did not make a mistake there. Amendment Act of 2021. It's those jargons that are crazy. You don't understand them. Why? But that's that. All right. So this is that one. Even this one, it became effective on the 31st of July 2022. So it fell off to be referred to as an amendment act. Amendment. Now it is the Criminal Law, Sexual Offences and Related Matters Amendment Act number 32 of 2007. This is this act. All right. It is this act. I gave you the copies. All the changes now that were presented to Parliament, adopted by Parliament, passed by Parliament, are in here, incorporated now in the Principal Act. All right. And then we have the Criminal Matters Amendment Act of 2021. All right. Became effective on the 5th of August 2022. With that one, also, it fell off. All the changes went into the principal pieces of legislation, Criminal Procedure Act and end, all right? So because I'm not going to be dealing with that one, the last one, it talks about the bail issues. And remember that women were saying that, people, the perpetrators are taken out of court, the bail laws are fair and end, all right? So now they got tightened together now with the sentencing, getting tightened, all right, the provisions of sentencing and so on. But there are grand innovations that have been introduced by that piece of legislation, which I'm going to pass through to them so that because they're relevant to you, all right? Now, let me quickly then move to the next item, all right? So now the salient changes on domestic violence, which is what I want to deal with, all right? So with the domestic violence in South Africa, if you ask, what is domestic violence? Domestic violence in South Africa is defined in terms of the acts of domestic violence. The acts of domestic violence are defined in the act, all right? So when you say that, what is domestic violence in South Africa? Domestic violence in South Africa, it is physical abuse, it is sexual abuse, it is whatnot. All these acts of domestic violence, the bill is what is called domestic violence. So we are the only country that has such a wide definition of domestic violence. And even now, I have only, listed the extended definition of domestic violence in terms of the Amendment Act. All right. So now I think that we've got probably about, is it 19 acts? Am I making it right or am I exaggerating? But it's a lot, all right? Acts of domestic violence that constitute what we call the domestic violence. So now these are the new extended, all right? That extend the definition of domestic violence. We have included coercive behavior. As you will see that the example, when somebody forces you to do something or stopping you to do something, it could be the way that you are dressing, all right? And say that I don't want you to do this, all right? It might be even with the way that you are cooking, all right? So it's different. The way that you are raising your children and is coercive behavior. So coercive behavior, if you have a partner who's doing that to you, then that partner is subjecting you to domestic violence, meaning that by that act of domestic violence alone, you qualify to receive the entire reliefs that are provided by the Domestic Violence Act. Controlling behavior, we included controlling behavior as well, is when a person then controls your movement. Don't go there, all right? Don't associate with these people, all right? Don't meet with your family members and. It is controlling behavior. on its own. Now, you can go to court and apply for protection order for controlling behavior. It's a type of abuse that is recognized by this act as an act of domestic violence, all right? Then we also included elder abuse. The reason that we included elder abuse is because the Older Persons Act, all right, recognizes the implementation of domestic violence. So then we said that why not? Why not recognizing and create a type of abuse? Because we know that they are economically abused, they are sexually abused. It's a lot of stuff that is happening to older persons. And all of us, we are getting to that age, all right? And probably I am already there, right? But we need to change laws, right? To talk for us. And whilst we are still walking, all right, having the strength, some elder abuse is also included. Then expose a child to domestic violence. And what we said here is that when we define this acts of domestic violence, let us not come with big jargons and all that. Let's make it very clear so that everybody can run with it. Expose a child to domestic violence is an act of domestic violence. It's a type of abuse, all right? So it speaks then to children. When you intentionally make your children to see, when you intentionally make your children to hear, all right? When you intentionally make your children or expose your children to the effects of domestic violence, all right? So you are, as a parent, if you are the actual, all right, the primary victim of domestic violence, then you go and share it with your daughter. You know, this is what your daddy is doing, and your daughter is 10 years old. You are actually perpetrating domestic violence against your child. And it is called expose a child to domestic violence because it's going to have psychological impacts and all that's going to affect his schooling and. So we are trying then to say that parents protect children, all right? And then physical abuse. With physical abuse, it was there, all right, in the Principal Act. But now what we have done now is to say that we have added an inclusive definition of physical abuse to say that it also includes, all right, when you are forced, all right, and any drug is you are made to, a drug is administered to you without a consent, all right? We are saying now that is that, or maybe somebody to say to you that take this medication. And it also occurs with older persons who are imposed to take this medication. So we are saying that you are actually perpetrating physical abuse when that person says that I don't want this medication and I don't want to take these drugs, all right? And for various reasons, then that is that related to person abuse, we included that one. And listen, with this one, the reason that we included it is because in the Principal Act, we have a provision there, Section 4, that says that if you are the victim of domestic violence, all right, and you are scared of going to court, or you are scared of taking any legal action, because there are many issues. It could be the fear of further retaliation, it could be shame, it could be embarrassment, it could be minimization, it could be a lot of stuff, all right? So as now, or it could be like, I'm so scared of this person, all right? So would you please then help me to apply for me or take the legal action on my behalf? Then you become the third party who's going to be assisting this victim with the application of the protection order. So you are the one who goes to court. You are the one who makes the application, all right? And the only thing that will be required is for her to give you a written consent. That was the position and is still the position in terms of the Principal Act. But what will happen is that now victims would refuse to give the consent, the written consent, and say that no, this is the father of my child, and this is this, and you are the mother of this girl. or you are the mother or the relative, the sister, and so on. And you are seeing the effects and the impact of this domestic violence. And you are like, she's going to die in this relationship. And the only thing that she's refusing with is to give me the consent, all right? So now we are saying that let's create a related personal abuse as a type of abuse, as an act of domestic violence. So with this one, I'm your relative, and I know that you are subjected to a form of abuse, and you must come to my place to escape, all right, to my house. So if the perpetrator comes then and threatens me with violence, all right, or threatens to break the door, okay, and do whatever, sending messages and all that, because I have rescued you or did something, or maybe in a meeting, family meeting, to say, hey, stop what you are doing. And then you threaten me with violence, all right? So you are making me a complainant. You are making me a victim of domestic violence. And you are perpetrating a related person abuse. All right? So now I'm going to put you aside as the primary victim. All right? As my sister, I put you aside. I'm taking my own action right now. I'm the complainant. It's my application. All right? And I'm making it against the person who's abusing my sister, who threatened me with violence or damage any property. It could be the cell phone, it could be what, it could be my car, and so on. All right? Then the spiritual abuse. We also included the spiritual abuse, which is then because of the spiritual belief that you have. Why are you forcing me to have your same belief system? Why are you stopping me from practicing my spiritual belief? Why are you using our spiritual belief, all right, and to justify abuse? Do you understand this? Both of us, it is our spiritual belief, all right, or our spiritual practice, but don't use it to justify abuse, all right? So it is called a spiritual abuse. So now, these are the ones that have been added to expand the definition of domestic violence. So when you see that there is no damage to property, there is no intimidation, there is no what, they are in the principal act, all right?
So the related person, is that new or is it now extended?
It is new.
Okay. So that protection order then protects you and you as a victim, as the relative and the victim.
So you are actually going to be taking the action against the person who's abusing your sister and say that you have subjected me to related person abuse because you are stopping me from intervening, or you threaten me with physical violence. But what it says is that there must be the threats of physical violence, or the actual physical. Exactly.
But then when you get that protection order, does that protect you and the sister, or just the person that
it protects you?
Okay.
It's gonna protect you, but at least there is something that has been done against that person. All right, there's a legal action that has been taken. All right, instead of having this person, going scot-free. Okay.
Looking at the questions that I know that child protection, I'm aware of how even if I haven't heard it, but I have no facts, so I don't just heard about the possibility of a child being molested.
Yeah.
That it is by law, my right to, I have to by law report that. That's so far. Is that have the same seriousness if I hear of someone who's being abused relating to whether it's discussed related person? Do I have a legal obligation if it is on issue at all?
Can you use this
this
act of domestic violence to apply?
Sexual harassment. So we have a legal obligation to report it.
Okay, with this one, you must be the related person.
Related as in family.
Related person, yes.
Right.
Related person to the actual victim, and also you must have a close relationship with that person.
So you can involve somebody who's a relative.
That's really clear for me.
Yeah. Okay. So
On the one on the medication, what about psychosis and now people who are bipolar, I can't schizophrenia, any form.
I've been getting those, eh? I've been getting those of people say that much medication.
No, since it's.
Yeah, it's just, I think you need to think, no, they're not gonna need to
You
think.
need to do- they know I think it's denial. I don't need the medication, but if bipolar.
You see what? It's our constitution. Our constitution says my body is my body.
Yeah.
Okay.
Get off.
So if you need something,
So-
they can use it.
So we must, yes, but with this one, remember that with domestic violence, you must have a domestic relationship with that person.
Oh, yes.
All right,
That's
so it
what
does not, does not, you must have a domestic relationship. Yeah, yes, yeah. This one, we are talking within domestic relationships, everything, all right? Okay. All right, so now let's get to this one. We have then section 2, capital A. It's a new provision. It's a provision that prescribes, all right, obligations or sets out obligations for functionaries. And now, who are the functionaries? All right, the functionaries are the medical practitioners, healthcare personnel, meaning that the nurses and everyone who is in the healthcare profession, social workers, nurses, educators, caregivers, all right? We have a definition of a caregiver in the Act, all right? And any other person that the minister would designate as a functionary. So now we are in a process where we are identifying more functionaries, all right? But we just want to give this act maybe just 1 year of implementation. And then after that, then we issue a gazette notice that will be expanding the spectrum of the functionaries. So if you're a functionary right now, you have responsibilities, all right? First, when you have a belief or a reasonable suspicion, okay? So a belief is that, hey, I believe, all right? So, but belief is a suspicion is less than belief, okay? Because belief, there are certain factors that made you to arrive at that decision. But suspicion, I'm not sure, okay? But it is reasonable suspicion. Reasonable suspicion. What the court does, it applies the objective test, all right? Which is a reasonable man's test. Meaning that a person in your position, all right, in your position would have had the same suspicion as you are having, as you had about this situation, all right? So it means that I'm not like conclusive. I don't need to have concrete evidence that says that this has actually happened, actual evidence. I don't need to have it. As long as I have a belief, all right? As long as I have reasonable suspicion that a child, a person with disability, or an older person is subjected to any of the acts of domestic violence, then I have an obligation. And that obligation is an obligation first to complete a report that must provide the reasons for such belief or that reasonable suspicion, and also submit that report to a social worker or to SAPS, all right? And also conduct a risk assessment.
Who does it?
That's a functional.
Okay.
That's a sign. So now we are getting to your situation. All right, you are a functionary, and then you are seeing that, why is this child next door, all right, pregnant at the age of 10? So I believe something sexual abuse is there.
Yes.
All right.
Yes.
So as a functionary, then I am obliged by law. It's not a responsibility. It's an obligation. When it is an obligation, then failure to comply with it attracts a sanction. All right. You will be charged. But what we are saying is that now, all right, you will not be charged. All right. if no civil action will be taken against you, no criminal action will be taken against you, or any disciplinary action against you, if your belief or your suspicion was made in good faith.
There's a gray area for me, because who decides that? Because you have siblings, for example, fighting over the person, and then they can make up all kinds of stories which they can prove. You know, they only feed my mother at 5 o'clock, and maybe there's some sibling rivalry. How do you know when it's bad?
So the moment, as soon as it goes to court, all right, we look at that, the principle of good faith, and it will be withdrawn. That charge will be withdrawn because, I mean, she's pregnant. She's pregnant. So that's why I took all these, because I'm obliged by the law to do that. She's pregnant. What made a 10-year-old to be pregnant?
I've only got 2 cases like this. One that I was where I was after. Well, the first one, I did report it. And I was able to report it to the correct authorities, so I legal advice first. I viewed it anonymously. Again, because at that point it was a belief. I was told that I had no actual facts.
Yes.
So, but on the second occasion, I had facts, and it was easier to report.
Yeah.
You know, so
And we need to take those responsibilities. And all of this, you see, this section 2, capital A, is built from Article 1 and Article 2 of the Presidential Summit Declaration. Remember that one, those 2 articles that say that you must take the responsibility to end gender-based violence and femicide, irrespective of who you are, a neighbor, a what, you must do that. All right. And now, let's say now you are not a functionary. You are not a functionary, and you are a neighbor. Okay. And you see that the neighbor's child is pregnant. You don't have an obligation. You have a responsibility, meaning that should you fail to take an action, we don't charge you. You have a responsibility, and that responsibility then makes you to approach the child and to go and lay a criminal charge, all right, or to apply for a protection order on behalf of that child and make a third-party application. Do you understand that? So all of us then we have to take an action. All right. Now let's come to mandatory reporting. All right. It's a new section as well, and it speaks to all of us here. All right. Section 2B. What it says is that any adult person. Do we have a child in this room? We don't have a child, so it applies to everybody here, irrespective of who you are. All right. So any other person who has knowledge, all right. This one now, and all of it, all of you see these 2 provisions. We are implementing Article 1 and Article 2 of the Presidential Summit Declaration, but we lifted them up from a level of responsibility to obligations. All right. So now it says any other person who lives here in South Africa. Who is in South Africa, all right, who has knowledge. Now we introduce knowledge, meaning that I got some facts, all right, who has knowledge, but is knowledge or, all right, belief or reasonable suspicion, okay, that who a child, a person with disability, or an older person, there is an act of domestic violence that is perpetrated against those categories of persons, all right? So with this one, as an other person, now, you will not be expected to do a risk assessment because you are a member of the public. You will not be expected to do a report as a functionary that will state all the reasons and all right. So with this one, you just go and make a report to the social worker and to the sub-official. Do you see that we have really, in this instance, with this amendment, elevated the role of the social workers all right, the caregivers and so on. So here, as an elder person, you must do that. And the failure to do that amounts to a crime. All right, it amounts to a crime. And it amounts to a crime. And it is a fine, or imprisonment sentence that will not exceed 7 years. All right, or both the fine and the imprisonment. Should you fail to do this, all right? So now let's get then to who can apply for a protection order. So we have expanded now the number of people who can apply for a protection order. It is the victim that can apply for the protection order. It's a functionary. Remember that we mentioned the functionary? The functionary can take an action and actually apply for the protection order. The third party who has a material interest in the well-being of the victim. I have a material interest in the well-being of the victim as a neighbor. Because, I mean, we have this noise, we have this for children and all that. So I have a material interest, all right? I have a material interest as a doctor. This is my patient. As an educator, this is my learner. As an employer, I have a material interest in the well-being of my employee because the performance will disintegrate, all right? Because of abuse and end, all right? So third-party applications, all right? So a person who has a material interest, who's not a functionary, can apply for a protection order. A person in a close relationship with the victim can apply for a protection order. Remember that we talked about that, all right? The related person abuse. A bystander can apply, can report, not apply. Report and say that, hey, somebody, all right, can take an action. A child exposed to domestic violence can apply for a protection order, all right? We did not.
Because many children can articulate what.
Yes, and the reason for that is because we extended the intermediary services to civil actions, so that if it is a toddler, then the intermediary will help you to understand that child's language and the name. Yeah, we have reduced times. I'm gonna get there. Otherwise, now it's tight. Now, how can I apply protection order offline? Offline, I go to court and make an application. All right, I visit the courthouse and make an application. But I can also make it online.
Yes.
Yes, I can make it online. And online we have done the solution, the online solution for protection orders is already done, and it's easy to implement. So yes, I think that maybe we need to pilot.
Yeah.
The shelters.
Yeah.
All right. We need to do that. So I'm
I'm
gonna do it because why? We are expecting you to make those online applications. All right. So you can do that. So we will show you. I'm gonna do that. It's my undertaking. All right. So we will do it. So that all of you know how to use that system and then before we can implement it, you tell us that maybe we need to change this wording and all right.
We currently access it now.
Sorry?
Is there a link to that application, right?
No, we have not yet opened it. We have not, but it's done. Yeah, we are still piloting. So that's why I'm saying that we need to pilot. Not yet.
Okay.
And we are required by law. The only thing that we have done is to translate the affidavit form, that application form. We have translated it in all official languages except for So now a person can do the application, all right, outside after court hours and outside court days. All right, and this is what we have introduced, okay? And it is all about, yes, it's an app. So the clerks of the court, they have, this is a system, we bought them already the tools of trade for them to be able at their homes, and there's a policy for overtime, and it's a lot of stuff that we have done, all right, to ensure that it still is done. And also we introduce also the SMS notifications. So what it means is that you make your application. As soon as you make your application online, it gives an SMS alert. And that SMS alert, it goes to the supervisor and also goes to the person who is a person who is on. I forgot this one. Who's on duty at that time? But it's on what? Forgot. All right. Maybe on call. We don't say on call, all right? All right, so yes, so then so they get then the SMS alert, that is an application that has been sent. As soon as you say send, it goes to their PCs. And then there's a push notification that will be releasing the SMS to you to say that we have received your application, and it records the time. You go to the time.
Good.
It records the time, and that time goes straight into the system as well. And then the processing of the application then begins, all right? And then the magistrate will consider the application, the clerk of the court will receive the application and look at whether everything that needs, all the fields that need to be completed are completed. But even the system doesn't permit you to get to the end, all right? It prohibits you from moving to the next step if you have not completed certain data metrics that are required. Then you go, then the magistrate considers the application, grants the application, and then it goes straight into the system. It goes first to the clerk of the court, and then the clerk of the court receives it, and the magistrate says that let this, you serve it to the clerk of the court online. All right? You can serve it to the respondent online, or you can release it to police so that the police can serve it. And all of that is happening online. So the clerk of the court will send it straight to the subs officials who is responsible for this at that particular time. All right. Then the police then will go and do services done by hand or online. All right. So the clerk of the court also can serve online, or goes to the sheriff, and the sheriff can also serve by hand or online. And there are timelines. I'm going to go to the timeline.
So the woman is filling this form in. And we're going to come back to her. She's doing it very good for that. Are there any safety features built into the app when she gets the response that if the user picks up the phone, says, "Oh, I see you ordered it," but there's some kind of safety word. You understand what I'm asking? So
Yeah.
when they create a setup, you do this funding, someone speaking to you, you know that that person's in trouble, even though there's other people in the ring, because we've communicated. Is there a way of responding to your message saying that your application has been successful?
Okay, so what you are telling me is that we need to include something like that. During the application, when a person says that I'm not safe where I think, all right? So that when they receive that notification, it is something that is, I will talk to our IT, all right? And see as to what we could be doing, because we have it in the safety plan.
Yes.
We have it in the safety plan. So why not here?
And also, once you've made the application, what's good about this, I'm assuming that they keep it on the database. So
Yes. It goes. Yes. Yeah. Okay, now we also remember that people who have been complaining that we're dying, getting the protection order, so we looked around different countries. What are they doing? And we found none. Countries that are progressive are only issuing the protection order in Israel. They don't have a solution. But we have to come up with something. So this is what we have come up with. All right, because we're saying that probably it's because you don't have the problem the way that we have it here in South Africa. So let it lead. All right. So what we are saying now is that now you can apply for the safety monitoring notice. All right. The safety monitoring notice, you can apply for it at the time that you are applying for a protection order. But you must be sharing the joint residence with the perpetrator or with the abuse. All right. So then you can, as I'm applying for the protection order, then I apply for the safety monitoring notice. All right. Or I can, all right, after I have applied for my interim protection order or for my protection order before it is issued, and apply. Because now I can see that situations have changed. So I need protection. All right. Or you can add a stage before. Or during bail application, when, let's say, because you know what's with the protection order, the release that are provided by this act is that one, I can apply for a protection order, or I can go and lay a criminal charge if the act of domestic violence amounts to a crime. For instance, economic abuse does not amount to a crime, but sexual abuse does, physical abuse does, a number of them, verbal, it's verbal, emotional, and psychological abuse also amount to a crime. All right, so I can, so meaning that I have these two actions that are available to me, so I can take them simultaneously, all right, or one after the other. I'm allowed to do that. I can go to, as I'm applying for the protection order because you beat me, I'm going to police and I'm paying the criminal charge so that you get arrested now. All right, so that's how it is. So now with this, with the protection order, so now what I'm getting to is now when you apply, when the perpetrator has been arrested, all right, and you are sharing residence with that person, and appears the act now, the Criminal and Related Matters Amendment Act, that one that I talked about, all right, which is now incorporated in the Criminal Procedure Act. So now what it says is one of the changes that has been made in bail provisions is that the police must not grant bail. Remember that police also grant bail. In other cases, is police bail, slang police bail. All right. Prosecutors also grant bail when that it is outside court hours or court days. So that is why you will see a person that you have gone to police station to lay a criminal charge, and then a few hours later is walking on the streets. It is because it's either that person made an application to the station commander or made an application to the prosecutor to be granted bail. All right. So, but now we are saying with this new amendment that no police bail, no prosecution bail in matters of domestic violence or in cases that relate to gender-based violence and genocide. Well, what we are saying is that it is in cases where the parties have a domestic relationship. Let me put it that way. Where the parties have a domestic relationship. All right. So now, when this person appears before court, what the act says is that they must make the bail applications before court formally. All right. So when they make the bail application before court, now what happens is if the magistrate is required by the law or the presiding officer to check the history of violence between these parties. All right. And then secondly, if they are sharing residence and there is no protection order that exists between the two of them. Now, the bail proceedings are criminal proceedings. All right. Now, the court must shift now, move from criminal proceeding to civil proceedings. And now do the inquiry for the protection order. So now moving from the bail application is done in terms of the Criminal Procedure Act. Now we'll move the proceedings and go into the domestic violence proceedings and issue a protection order against the perpetrator, so that if that magistrate sees it fit and is according to the principles of justice, that you be granted bail. And you don't have a protection order. There's no protection order that exists between the parties. So what the law says that don't release this person on bail without having issued a protection order. So it is also in those circumstances where the victim, and also if it is a matter between parties who have a domestic relationship, the prosecutor is not allowed to entertain that bail application without consultation with the victim. So you must get all the risk factors and all that from the victim. So the victim now, the voice of the victim is heard in bail applications, is now heard. And also, the next thing is that now, when that victim says that, okay, all right, now the magistrate is granting a protection order in my favor, I also want the safety monitoring notice. It can also be issued at that stage. That's where I was getting to. So now, I was going to a criminal court, all right, because the abuser has applied for a bail, all right? And now, in the interest of justice, the bail is granted. But I will leave the court with a protection order and the safety monitoring notice. It depends on your pocket. No, it must be. So,
if somebody applies for bail, and you're perpetrated, do I get, as the victim, do I get informed that they're applying for bail? Okay. That's fantastic, because sometimes people don't.
Now, there is no prosecutor who can hear a bail or entertain, consider a bail application without consulting you as a victim. We change that law. We change it.
Is this being rolled out again?
Yes, that act became operational with effect from the 5th of August 2022. So now the criminal courts now are issuing protection orders.
So I'm coming to the question with bail. I'll ask you because sometimes what happens is that you say after hours, because by everybody's also and they can get bail.
Oh, you mean
out of the
no, they are not allowed now. If you go and you lay a criminal charge and that person is arrested, we'll wait until the day of the court.
But what I'm saying is, you know, the body system that was in the whole system.
Yeah.
You know, I'm talking about these and you know the history. And then you suddenly hear that they are then being given bail. You see, like if the court order is not being, what do you do? What does the
It's before court now. It's a formal bail application. The person now that you're gonna say that is corrupt now is gonna be the presiding officer.
Okay.
Because the matter now is before him.
So they do
At all. Even the prosecutor, even the prosecutor, when the prosecutor accedes with the defense that the bail must be granted, this law that we have introduced now, it says that give reason. Why? Why are you agreeing with the defense? Before the magistrate can make a decision.
So you as a person who made the charge, you can ask for those.
When you, sorry?
Can you ask for those?
Yeah.
Exactly, because your voice must be heard. Let's say, I'm saying now, all right, your perpetrator applies for bail. This new law says that the prosecutor cannot consider that without consultation with you. It must be done in consultation with you. Now, in court, the prosecutor may be talking to you and say that I am seeing you again, let us give this person bail. Now it comes to court. Before the magistrate, the act says that prosecutor state all the reasons as to why this person must be granted bail. Why are you acceding, all right, with the defense? So it's tough. It's tough for the prosecution, and the powers of bail granting have been taken after hours. Yes.
Okay, please.
You see? Now, okay, I have mentioned all of those. Now I'm just thinking that the notice then, for you to get that notice, there must be an act of domestic violence that is allegedly perpetrated. You must share the joint resident with the perpetrator, and in court may ask for supporting affidavits, and the supporting affidavits can be, now we are recognized videos, all these WhatsApps, online, and so they are also part of. And yes, yeah. Yes. Counts as it's recognized, and we also have a provision. I'm going to get to it. You see it. So now, then as soon as this notice is issued by court, the act says that within 2 hours, the victim must be notified and told that the notice is in operation. And that notice, it goes to the court, I mean to the police, and the police, the station commander is required by this act to nominate a police official who is going to contact you electronically and do physical visits, but without the permission of the perpetrator. If the perpetrator is refusing access, it says that you can gain entry by force. The police to check whether are you safe or not. All right. And also they are required. They don't need. And they are also required. They are given a period. The magistrate will give a period for that notice. All right. And then so that it is reviewed, the conditions and all that are reviewed. So it says that the police, after the expiry of that period, they must submit a report to court of the safety, because it's all about the safety measures, all right? Now, social media now. We have section 5, capital B. Section 5, capital B, that recognizes now the role of the electronic service providers. Your MTN, your Vodacom, your what, and all that. They are ordered by the court. If you come and say that, has been sending me, this is an emotional, verbal, and psychological abuse, or he's harassing me, sending me messages in end. All right, sending me dead flowers, all right, and all that, and sending me pictures of dead flowers, or took my photograph, maybe we did something together, we were naked, and social media, and you are like, hi, yeah, we were together when we did this thing. Why is it on social media? And nobody, you are like, whose face is this, all right? And nobody knows. Now the court issues an order to Vodacom, to any electronic service provider, and say that you're gonna give us the full details of this what is it? Account. The account, yes, I wanted to say account. Of that account, and you are also going to give us the proof of information who sent it and also the content from your back end, give it to us, and also who disclose that information, all right? And they can also be ordered to remove the content, all right, from social media platform or to disable access to that information. And these are just number of the things the electronic service. Yes, it is the court that is issuing that order.
Could they convict someone on that? Could they convict someone on that?
The electronic service provider, if it fails to adhere with the court order, is in trouble. All right, there's a sanction against them. All right, now you are a person who do not have money and all that, so because it says that you can do that at the request. You can pay for the electronic service provider to provide you with that information. And if you don't have money, the state can pay for you. Or at the end of this whole thing, the court can say that respondent pay. And there are tariffs that are already set. So the service provider cannot charge you more than the prescribed tariffs. And they are low. All right?
Yeah.
So they cannot charge you. Now in court, all right? No changes in terms of court. Now you can do the court accompaniment service as people who are in sheltering services, all right? They are penitents in terms of this. Why? It is because a child can't go to court alone. A person who's traumatized can go to court alone. An older person, a person with certain disabilities. So court accompaniment services. Now we are recognizing that we're going to give you the witness fees. Should you do that? All right, we give you the witness fees. So you will get your food allowance. You will also get the return traveling costs. All right, so you qualify, but then you need to notify the court that you're going to be coming with this person, so that you get the witness fees. Now, when this person is testifying in court, in terms of the act, can come with not more than 3 support persons. You can go there, people who are in sheltering services. And as a support person, you are sitting next to this person, that's all. All right? If you want to need support and all that, but when you are in court, they would want to check your hands that you are in. You know, but it's just for support, all right? Court preparation service, when a person comes to court, the prosecution provides the court preparation services. I'm giving you the basket of services when a person comes to court, all right? Intermediary services, you can actually do intermediary services, all right? And I'm gonna give you a document where you're gonna look at the qualifications. But now we have made the qualification to go to a level of a caregiver to provide intermediary services. In camera proceedings, Section 11 says that the proceedings that are held in terms of the Domestic Violence Act must be held in camera. When we say in camera means that we clean the court. So that is only certain people that are listed in that provision that must be present when you testify. Virtual proceedings, the Criminal and Related Matters Amendment Act of 2021, all right, introduce virtual proceedings. So meaning what? A person who is in a shelter can testify virtually. There's no need to go to court. No need at all. All right. As you have seen Besta appearing virtually and all that. It was after what? The 31st of July. No, the 5th of August. 5th of August 2022. Now
they also help the role.
Sorry.
With the not cases that
Yeah.
that you can do it tomorrow.
maybe you are called in the shelter to testify. You say that, no, I want to testify virtually. I don't want to go to court. So you can testify.
Especially when people are from.
Yes.
But now, that makes sense to also
Mm.
interview whatever the perpetrators were, instead of these police cars driving around with hundreds and hundreds of criminals. Doesn't it make sense to also do it virtually, like when somebody has to appear in court, let them do it virtually from prison or from.
Yes, they do that, they remand, yeah. Yeah, people got there was a buzz when Bester appeared virtually. So he was appearing virtually because this act became operational on the 5th of August 2022. So virtual proceedings are permitted. You can testify as a witness virtually. When you are called and you got a subpoena and say like, may I testify virtually? So with effect from the 5th of August, you can. So also non-disclosure of identity of the parties in terms of section 11 of this act. People, if you tell them, your clients, that your identity, it is an offense to disclose your identity, all right? And the publication of your proceedings. Now, victims can also obtain legal aid services. Okay, you can obtain legal aid services now. Previously, it was not there, but from the 24 demands of the total shutdown, all right, they asked for the legal aid service, so now it is available. All right.
What perpetrators would use that system? They now.
No, you now as a victim. I'm talking about you now as a victim. Oh, they abuse it. They abuse it. Section 35. Oh, we need to amend that section. Now I'm ending now. Section 13, the service of the documents. All right. So now the service is done by hand, also done electronically. When I'm saying that is service, I mean the protection order, how does it get to you? The monitoring, the safety monitoring notice, how does it get to you, and all that, all right? And also to the respondent. So now, if it is an interim protection order, if it is the service is going to be done by hand, it must be done within 24 hours from the time of issue. So that is why our system, the moment you online, when online you send, it records the time.
So time when the application was sent or on
issued by magistrate. But we also measure for us for the service standard from the time that we have received the application. But the act says that the service must be done within 24 hours after the issuing of the protection order. So as soon as the magistrate says that issued, all right, it records the time. So it ticks, the clock ticks for the police. It ticks also for the clerks of the court and the sheriffs. There are 3 persons who can do service in terms of the Domestic Violence Act. The clerk of the court, the sheriffs, and the police. All right. The clerks of the court, they do online service because they are not expected to leave the court space. All right. So they also do service by hand when you are court. But all it must be done within 24 hours. And it can, when it is done electronically, the act says that as soon as reasonably possible. It says immediately or as soon as reasonably possible. All right?
Timing would be affected or
every time. It applies. Now, the regulations have set us. As a result, now I'm going to have a meeting. We are trying to implement these things and put documents in order and all that. So there's a task team that I have set to ensure that with compliance with Section 15 of the police, the sheriffs, and the court personnel. Now, final order. When you are granted with the final order, this is the interim. The interim, as you know, that you do it ex parte, it is granted without the notification of or the participation of the respondent. All right. The final order that is on the return date and then the final order is granted. It says that the service must be done within 48 hours or as soon as reasonably possible. The safety monitoring notice must be served within 2 hours. Do you see this? So these are the times. Now, the role of the shelters. This is your role. First, you are required to conduct risk assessment. We have done the risk assessment tool. There is one that is also in the prescribed form. We are amending it, and we are working with social development. I want the sheltering services to participate in that activity, all right? So that we use one risk assessment tool everywhere. Secondly, safety planning. Safety planning, I'm doing the simple English editing of that document. It has already been developed. You will have it. You have to do it. The safety plan is about, and when the person now wants to leave and go home, you have, in the shelter, you have to assist that victim or the survivor with the completion of the safety plan. And the safety plan will be helping and saying that, okay, this is where does it normally happen? It normally happens in our bedroom, all right? So move away from the kitchen, all right? And if it happens in the bedroom, and this is what you need to do, move to a safe place, all right? Identify the safe place. If it is in the kitchen, move away from the kitchen because there are dangerous weapons dangerous things that could be translated into dangerous weapons, boards, knives, and so on. Then it also says that have a rescue person, all right? That you will alert and send a blank SMS or whatever to say that I'm in danger. And also contact a shelter that say that I'm gonna be escaping to you and. So it's all that plan. It's a booklet, but it's also available in a lipstick holder, all right? So that they don't see it, all right? And also for men, it is in the lip eyes holder. You see the lip eyes.
Oh, wow.
So you just tell your party, your spouse that, no, I use lip eyes now.
Steve?
Noted. And then the other thing is that you report, all right? We talked about that. Those is your role. You must report. A knowledge, belief, a reasonable suspicion, all right? You must assist the staff's court when sheltering services are needed. Section 2 says that the police must contact the sheltering services. It also requires us the regulations that the sheltering, we give our courts an update. We have already done that. We have your directive that is with the clerks of the court, which must be updated every 6 months, all right? And you must assist with the online application and assist also with the application for safety monitoring notice, provide support in virtual proceedings, all right? And provide court accompaniment service, appear in court as a support person, provide ad hoc intermediary service, all right? The Act now recognizes ad hoc intermediary. And I don't know as to why you are not doing this thing, yes? Because we have the determination of persons or categories or classes of persons who are competent to be appointed as intermediary services. As intermediaries. So now we have dropped it to a level of a caregiver. And in this financial year, we set a target of appointing 100. I'm telling you, we're still at 27. People are not coming through. And mind you, we increased the tariffs. For you as an ad hoc intermediary, if you go to court, remember that a case will just be for 2 or 3 hours. You will leave, if that case is heard in a district court, you will leave with 1,200.
That's going to be your motivation.
So if you are appearing at the regional court or high court, you will leave with 1,440. So you can't tell me that you don't want to do that. Can't tell me that you can't do that. So that is that. So I would like you to go and get this information. It is in our, so I'm really asking you, please. You see now, we've got 7 assistant director intermediaries. They're supposed to be 9. And we have got 160 full-time employed intermediaries. We have 72 ad hoc intermediaries, and they are expected to be 145 by the end of this financial year. Nobody is applying. Nobody wants. And all that application is not even something that is, if you want, we can give you your details right now, so that we can put you in
What
the
is that involved?
intermediary. We train you as soon as, because there is no qualification for intermediaries. So our Justice College has developed a course for intermediaries. And an intermediary is a person who is sitting in our, I should have given you the photograph of that. You sit in a private testifying room, all right? In our court with a child, you are trained to know the child's language, to communicate with persons with disabilities, and to communicate with older persons. And what is your role in court? That person, you are wearing the earphones, all right? There's a screen that is there. That screen is, we have a dual CCTV system, all right? So, in the private testifying room, your screen is blank, because we don't want the child to know that is in court, all right? We don't want to traumatize even the older person and the person with disability. We don't want to do that, all right? So it's only when the question of identity is in dispute that the screen will be open, and then the witness will say that it is so and so. And the system that we're using is able to zoom to an extent that a person will be able to identify even a small amount of disputes. All right, that's the system that we're using. So your role as an intermediary, you are conveying what this person is saying. A child is saying it to you in a child's language, and you are telling the court that this is this. And you are wearing the earphones, and you don't have to know the legal jargons. We train you on how to do this thing. Simple. And you're going to be called. You are sitting at home, you are called. Come, we have a child. We're going to have a case of a child. And now the intermediary services have been extended to civil proceedings. So civil proceedings are so huge. So should you get into our database, definitely by the end of the month, I don't know how much you'll be making.
Maybe social workers.
I don't know. I don't know how much you'll be making. All right. So please take this advantage. We are really, look now. So what you need to do, all right? See, the provinces are struggling. So since May, they've only appointed 27.
Okay.
And it's my project is frustrating me. They are reporting to me. They say that they can't, people are not. I said now, during the 16 days of activism, they should go to the radio stations and call people to come. Because you must check, go to our website and check the determination of persons and categories who are competent to be appointed as intermediaries. If you want me to send you that document, I can, before leaving, send it. Because it's in my laptop. We are left with 73. The training, it takes, I think it takes 5 days. you will be, it's done by the Justice College, all right? So they will call you and say that this is where this province, we're gonna be training at this place and all that. And it's my budget that's gonna pay for you.
The entrance.
It's my budget.
The qualifications,
So I have put only because I didn't know the people that I'm gonna be talking to, all right? So I put, oh, I did not, okay.
Okay.
I did not, I excluded that slide, okay? So, but what you need, I'm gonna give you those. I'm gonna give you, before leaving here. Yes. So, yes, we need to. I mean, we can't be struggling the way that we are. And just to ask people to come and assist us in court. And they are not. And we are not saying that we're not saying that we're gonna be a full-time employee high. We are saying that give us your expertise that we have developed with our course and your availability. That's all. So you must be vetted. That's what I said to you when I was here last time. Be vetted, people. Please be vetted. I'm asking you. Be vetted. Why are you not vetted whereas you are doing shelter and services? You must be vetted. Why? Is it because a person who is being cared for in a shelter that provides services to victims of crime, now, in terms of this act, is a vulnerable person, so needs to be protected from everyone who is in that shelter. So meaning that the cleaner, the security guard, the social workers, the people who are coming in, and what caregivers, that person needs to be, you need to be vetted. And should you fail to vet, this is what happens. As an employee, all right, if you are an employee, you fail to disclose that your name is in the register, National Register for Sex Offenders, all right, you are committing an offense, all right? And so you must be vetted. And this is the fine. Upon conviction, you'll be liable to a fine or to an imprisonment for a period not exceeding 7 years, or to both a fine and such imprisonment. If you are an employer and you are in a shelter and you have not vetted your people, you are committing crime. So I'm supposed to call SAPS right now to arrest you.
I'm going to take yourself. Address there.
I'm done. Shift the blame. Okay.
Normally for applying online.
Yeah.
So the question of for the conviction order.
Yeah.
Sometimes maybe the victims cannot get to a shelter below the station. Right, for them to, so they can't, you're saying that sometimes the victims, that's what. And if we don't know our shelters that are near to our, so they go to the police station. Will the police station be able to help them, or will they save them, or Section 2
says that in the regulations, making it so explicit and expressly so. What they are saying is that police, every police station must have a director of shelter. Every courthouse must have the director. So our clerks of the court they have, and with us, we are saying that it must be updated every 6 months. So we got it from a social development. So because we are required to do.
And they take the victim to the shelter, or must they go?
It's the police.
They must take to
Yeah, it's the police. They are required to do that.
I think last term at school, we were asked to fill in forms and the police commissioner came. I think that was the vetting that we did.
No, this one, it is done by the National Register for Sex Offenders.
So that's because
And what
the
you do,
started.
the forms are available in our website.
Okay.
The only thing that you need to do is to go to police and take your fingerprints.
Please come to
And
the
we assume
website.
that's about 75 residents.
Okay, so it's something else, so.
Should a person, if you are an employer and a person, you have hired this person, all right? And the name is in the register. The X is that fire that person. If you fail to fire, you are liable to that sentence. That okay.
What should we do, when people could leave and say to the victim, okay, now we are from the court before, protect people are all instead. Your husband.
We stopped it. I think it was not supposed to be. It was not supposed to. You tell me which court is doing that. And which the police, they are not supposed to do that. It has been changed. That's why now they're even timelines and what.
Yeah.
So many changes that have been done. All right. It's just this. But you can take my cell phone number. It's 084. If you are interested to be an intermediary. 084 702 7122. And my email address I get but I have my PA who's reading them. All right. So so please don't penalize me. I have somebody who's reading my emails. Okay. I said 084 702 7122.
And your email address?
It's P
P.
capital letter for please.
Praise worship this.
Yeah. And
Any dot.
K-A-N.
Any dot or period.
This K is capital letter and the rest is yeah. There's no H here. Please don't put an H.
A-M-P-U-L-S.
Yeah, it's KAMPL at justice.org.za. But you know, I respond, let me say this, I respond better WhatsApp. Yeah? Don't send me an SMS. And with emails, I told you, emails. I tell people that I can't manage your
Very
email.
much lost there. Thank you. Give me so much confidence in the justice. Thank you once again, Advocate Kamala. We really appreciate it. Thank you so much. There's everybody on the chat. Thanks everyone on the chat. We'll be logging off now. Thanks to all.
When I was actually in